Welcome to The Explainer. Today, we're diving into a seriously high-stakes legal drama that cuts right to the heart of South Africa's democracy. We're unpacking the intense legal battle surrounding President Cyril Ramaphosa's impeachment process. It's a massive clash between the executive and the legislature, mediated by the judiciary. And it all revolves around one huge question. Can a court actually stop Parliament from holding a president accountable even temporarily? Let's get right into it.
Take a look at that official crest. It really grounds us in the sheer legal weight of the document we're unpacking today. This is case number 2026-138228 from the High Court of South Africa, Western Cape Division, Cape Town. Delivered on July 24, 2026, this is a major judgment where three prominent judges had to decide whether to halt public impeachment hearings against the president. And, well, spoiler alert, they absolutely did not agree. It was a fiercely debated split decision.
Okay, let's dive into this and look at our roadmap for today. First up, the Phala Phala impeachment timeline. Second, the legal hurdle. Third, the minority dissent. Fourth, the majority opinion. And finally, the final verdict.
Section 1, the Phala Phala impeachment, tracing the timeline of events.
Right, so to understand these complex legal arguments, we really need to see how we got into this courtroom in July 2026. The whole thing kicked off back in February 2020. A massive sum of foreign currency, we're talking around $580,000, was stolen from a sofa at the president's private Phala Phala farm. The theft was handled internally by the Presidential Protection Unit rather than through standard police channels. Fast forward to November 2022, and an independent panel reviewed this, finding prima facie evidence that the president actually had a case to answer regarding constitutional violations. The National Assembly initially voted to just drop it, but then in May 2026, a constitutional court ruling revived the entire process, making the impeachment referral compulsory. So, facing imminent public hearings, the president urgently approached the High Court in July 2026 to basically hit the pause button.
Moving on to Section 2, the legal hurdle and the requirements for an interim interdict.
Now, it's crucial to understand that the president wasn't asking the court to declare him innocent. He was asking for an interim interdict. Think of it as a temporary freeze on the parliamentary hearings until a later court could fully review if that 2022 panel report was legally valid. But to get that pause button pressed, the law requires him to prove four specific things. First, a prima facie right, basically a right on the face of it, even if there's some doubt, to not be subjected to an unlawful process. Second, irreparable harm if the hearings go ahead. Third, that the balance of convenience favors pausing the process. And fourth, that there's literally no other satisfactory remedy available to him.
Now, what's really interesting about this is something called the outa test. Because remember, the president isn't just suing a regular person here. He's asking the judiciary to stop the legislature, Parliament itself, from doing its constitutional job of holding the executive accountable. Our courts use the outa test for this exact scenario. It basically dictates that because of the separation of powers, courts should only grant a temporary restraint against another branch of government in the clearest of cases, under truly exceptional circumstances. So the bar here, it's set incredibly high.
Which brings us to Section 3, the minority, let Parliament work, and Judge Francis's dissent. So the three judges looked at this massive legal hurdle, and, well, they completely split on whether the president actually cleared it. Let's start with Judge Francis, who wrote the minority dissenting opinion. He was deeply concerned about the separation of powers. Take a look at this quote. "The remedies sought, an order freezing Parliament mid-function, is itself the intrusion that the doctrine restrains." He basically argued that the Constitution specifically tasks the National Assembly with holding the president accountable. By stepping in to halt that mid-process, the court would be inappropriately interfering with Parliament's core constitutional duty.
On top of that, Judge Francis analyzed the president's underlying argument. The president claimed that the initial panel used the wrong legal standard, but Judge Francis noted that this panel was simply a sifting body working with written documents. It wasn't a trial court deciding guilt or innocence. Because Francis felt the president's chances of actually winning the future review were pretty weak, he concluded that the harm the president faced was also weak. You just can't claim massive harm based on a flimsy legal challenge.
And this brilliantly illustrates the massive divide regarding what actually constitutes irreparable harm. Judge Francis argued that an impeachment inquiry is a multi-stage, highly protective process. The president would have lawyers, he could cross-examine witnesses, and Parliament still had to vote at the end of the day. The harm isn't irreversible. But Judge Davis, writing for the majority, strongly disagreed. He argued that if the president has to go through public hearings based on an unlawful report, the deep humiliation and damage to his dignity is totally permanent. The public spectacle is recorded for posterity. The genie.
All right, Section 4, the majority,
the rule of law, and Judges Davis and LaGrange.
This brings us to Judges Davis and LaGrange, who formed the majority and ultimately granted the stay. They totally acknowledged the public's desire for accountability, but they anchored their final decision in strict legality. Judge Davis wrote, "The public have an equal, if not more compelling interest in the lawful exercise of state power." The absolute core of their argument here is that Parliament cannot hold the president accountable by acting unlawfully. If the foundational report is flawed, then the entire process built on top of it is fundamentally tainted.
But you might be wondering, how did the majority actually get past that super strict outa test? Well, they used a kind of sliding scale approach to the separation of powers. While the minority felt high deference to Parliament was needed, the majority argued for less deference. Why? Well, because reviewing a set of parliamentary rules and a legal report isn't some complex political policy decision. Interpreting rules is exactly what courts do every single day. It's totally in the court's wheelhouse. So stepping in causes way less separation of powers harm than if they were, say, interfering in a massive new government policy rollout.
To counter the minority's concerns about stepping on Parliament's toes, the majority introduced a really powerful counterweight, rule of law harm. This is essentially the damage to our constitutional framework if a court allows a potentially unlawful, punitive process to just drag the president through the mud, only to later declare, oops, actually, that whole thing was invalid. The majority argued that protecting the pure integrity of the process is just as important as the accountability itself.
So the crucial point is perfectly captured in this incredibly punchy quote from Judge Davis. He stated, "If the impeachment hearings were to be allowed to continue only to be set aside later, the rule of law will have been made to look like an ass." I mean, wow! The majority concluded that allowing an agonizing, highly publicized parliamentarian inquisition on a potentially unlawful foundation would just completely cheapen the rule of law.
Finally, Section 5, the final verdict and what happens next.
So, with the 2-to-1 split in favor of the president, let's move to and see how this builds into the final binding order of the court. Step 1. The Speaker and the chairperson of the impeachment committee are officially interdicted, which means legally halted from proceeding with public hearings immediately. Step 2. This pause is only temporary. The actual legality of that 2022 independent panel report will be thoroughly reviewed by the High Court in September 2026. And Step 3. Depending on what that September court decides, the impeachment is either permanently dead in the water or the pause button is lifted and the president faces the hearings.
I want to leave you with this question to ponder as we await that big September review. Does temporarily halting an impeachment protect the ultimate integrity of the rule of law, or does it simply delay vital democratic accountability? It is a highly delicate, high-stakes balance, and as this split high court decision proves, even the top legal minds in the country view it from completely different sides of the scale. Thanks so much for joining me on this explainer, and keep learning.